Welcome back, everybody, here and at home. We don't have a lot of control over elections, and we don't have a lot of control over markets, but we have quite a lot of control, kind of total control, over what we do in our estate planning, within reason. And I want to welcome back Kevin Horner and Tonya Knauth, who both practice estate law here in Houston, and we'll be happy to talk to any of you about your needs. And many of you may already have named your beneficiaries and set up your wills and so on, but it is an ongoing process, and your lives may change, and your goals may change, and your finances may change, and your needs may change. Hannah and I are in the middle right now of doing some estate planning work with an attorney who has helped our family and helped my parents, and we needed to meet with this attorney to coordinate some things because there are some family partnerships that this attorney worked on. And so there's all sorts of different angles and reasons why you might need to confer with an attorney, revise your documents. And what I have been interested in, really, I'd say over the last year, is this issue of naming beneficiaries, because I've seen some clients come in and have named beneficiaries where I've had some, I don't want to say doubts, but maybe just some concerns that maybe something that was done was, and I don't even want to say unintended, but just sort of suboptimal. Maybe some amount of money was left to a very young person, and that young person might not be able to handle it or receive it. Or maybe they have the temperament to receive it, but the amount that is coming to them and the timing that it's coming to them could be improved. I've seen situations where I've thought clients should more strongly consider, and we're in a position to more strongly consider, some charitable bequests. But the client wasn't for one reason or another. And so I really wanted to have this session to talk about naming your beneficiaries' do's and don'ts, and really appreciate you both being here. So with that, we're going to, we made some questions. Catherine and I made some questions. We want to make them sort of general questions. We want to get too specific about them. There's a lot of mechanics, but Tonya and Kevin will get into the mechanics today. We wanted to ask some questions in a very general, open-ended way, and felt that would be the best thing to help all of you think about these general questions, because this is probably the way you think about it as well. And so the first question is, what considerations go into deciding who or what to name as a beneficiary? And Tonya and Kevin, either one of you can take it at any time.
I'll start.
You're good.
Nice
You're good.
To be here and see some familiar faces in the room. And I appreciate that Leonard does this every year. And I appreciate the opportunity to talk about this subject. I want to start with the direct answer. I know nobody's hearing direct answers to direct questions on TV these days when we're interviewing politicians. So I'm going to answer the question. It depends. A myriad of considerations, but the primary consideration is, does it fit with a holistic plan? You really need to look at your whole plan. I want everyone in the room to understand, who may not understand, that your beneficiary designation on your financial accounts is a contract with the institution holding the money, and they will pay out according to your designation without regard to your will or your legal heirs. So it's very important that we get that right. That's good cocktail party conversation, by the way, because 90% of the people who come in to visit with me are unaware that no financial institution is going to look at their will to understand how to pay out financial accounts. So we need to name beneficiaries on financial accounts as a part of the larger plan. We may include some assets in a will, but we need to understand that beneficiaries of financial accounts will receive money directly from the institution. So I'd start with that, and then I'll let Kevin fill in.
Thank you. Thank you. I also like to say thank you. Thank you for having me and letting me have this opportunity to talk. I agree with everything that Tonya just said. I'll take it from a slightly different perspective beyond the beneficiary designations. I would stress, and this will probably be a theme in many of these questions, this is something we obviously preach to clients, is you want to be very intentional about what you want to do with your beneficiaries. And by that, I mean, it's a very simple answer to the first question of who are your beneficiaries? Start with whoever it is you actually want. And I say that because sometimes there are difficulties with beneficiaries that you might choose, and clients will sort of self-diagnose the solution to the problem, and then the attorney isn't in a position to help. So say, for example, you might have a beneficiary who has a long-term disability. That person is using government benefits. A lot of times in these situations, it's a child who's had a long-term disability, and they're using Social Security, they're using Medicaid. What that parent has heard that whole time is they can have no more than $2,000. So what they will do is they will disinherit the child. That does not actually have to happen. If you start from the perspective of, I'd like to leave an inheritance to this person, then the attorney in that position or through other means can help you find the right way to do that. In that particular case, it's you'd leave a supplemental needs trust, money that's going to be available to the person, but not actually disturb their benefits. You see this in situations with difficulty with money management. You see this in situations where, let's say it's a child who you're worried will get divorced, and maybe the money you left them very quickly goes back out to the other person. If you start from the perspective of, this is who I want, there are solutions to those kinds of problems. For example, with the divorce, you could, again, leave it in a kind of trust so that if they should get divorced, whatever you left them stays with them and doesn't go to future ex-spouse. The one other point I do want to make now about the intention, because I find this happens a scary amount, is people assume they're beneficiaries, and they assume that things might go to the people that they expected or wanted, and sometimes that's a bad assumption. What do I mean by that? If you do not have an estate plan or you don't have a beneficiary designation, Texas has a rule, it has a law that lays out where your stuff goes. A lot of times that is spouse. It is not always spouse. And people assume things like that, and they assume that everything will go to the person they were intending. By way of example, if you are married, but you also have children not of that marriage, such as a second marriage, blended family, it's a very common scenario now. Not everything when you die goes to your spouse. Probably it goes to your spouse, half, and half to your kids, all of the kids. That is probably not what people intended. So if you do not want a default setting, you want to be intentional about what you want between the estate plan you put into place and the beneficiary designations that you use to sort of wrap around and work with that. And as a quick aside on that last point, the other reason why you don't want to just assume it will go to the right people is, even if it does, chances are it's a lot more involved process and a lot more expensive to actually make it happen. By way of example, if you have a will, you'd probate that. Sometimes people are okay with that, sometimes they're not. If you do not have a will, you're still going to go to court and you're going to do an heirship proceeding, in which case not only are you paying the attorney to do that, the court will have you appoint another attorney who has to be paid by your family to make sure everything is as it's supposed to be. So being intentional and being holistic about all of your beneficiaries and who you want to leave things to can avoid a lot of problems.
Did that answer your question, or do we want to talk also about how we decide who to give our stuff to generally?
Let's do that, Tonya. I like that idea, and I don't know if the legal profession has some framework or rubric for thinking about that. I tend to think about who needs money, who wants money. You know, these are sort of the ways that I tend to think about it. And I don't know if the legal profession thinks about it or counsels in that way. When there's children involved, there's always the question of equality, you know, and so maybe we talk generally in those sorts of terms: needs, want, wish,
Right.
et cetera.
Right.
And keeping in mind that really what we're talking about, I think, is love, right? I mean, at the heart of all this is showing love or affection for a person or an institution or an organization. And how does that factor into it also, this emotion of love and care in making what essentially is can be a life-changing gifts
Right.
and between giver and receiver. Yeah.
And what do you want the legacy of all of your hard work over your lifetime to be? Where do you want the worldly goods that you accumulated to go after you're no longer here? Um, Obviously, as an attorney, I wear a counselor at law hat, and sometimes I wear another counselor hat. Most of my clients come to me already knowing generally how they want to leave their stuff after they pass away. It's naturally easier for some than for others. If they have all high functioning children who are financially independent adults, maybe even have the same number of grandchildren by each child, and it's so easy to just decide to leave everything in equal shares. But families are different. Families look all kinds of different ways. Blended families, families with lower functioning, sometimes with special needs, but sometimes people that just don't function as highly as others. How we leave money to children, spouses, siblings, other family members, and then charity is just a really highly individual exercise. I like Kevin's approach. I like it when clients come to me and say, these are my general desires. I don't like clients to get too hung up in the how I'm going to accomplish that, because guess what? That's our job, to try to help you structure it. If you want to leave money for a person that you know is not going to responsibly manage it for their own benefit, we've got a solution for that. If you want to leave money to a minor, we've got a solution for that. So I would say a conversation is generally had, but many, many times people come to me already knowing generally what they want to do with their money.
I like this idea of conversation, and I want to say that, we meet with you all on a regular basis, and we're always available to help and have that conversation with you. And it dovetails very nicely with the work that Kevin and then Tonya do. And we're always available to have a conversation. You may be thinking about something in particular, and our office, my office specifically, is a really good place for you to air some ideas that you might be having about, I'm thinking of including this person or this organization as a beneficiary, but I don't know. And conversation really is a good way to talk about it, where we can get it. What is it that you're trying to do? Next question: how do you decide when it is best, during or after your lifetime, to provide financial assistance to a beneficiary? This is a big question, right? Because you can help now or you can help later, and those are two very different things.
So in true legal fashion, it depends, right? And to be honest, in this one, it very much depends. So there are a lot of issues that a lot of times the attorney is thinking about when you have a consultation about these kinds of things, in terms of, does lifetime giving make more sense than leaving something or someone to something at death? And again, as the ongoing theme, it is very client driven, very client specific, depending on what your goals are. I would suggest first, it is very helpful if you're thinking about gifting to do a sit down conversation with your excellent financial advisor and making sure that you have sufficient money to do that. I have been in the situation more times than I can count where usually not the client, but more a child of the client has suggested they should have a meeting because isn't it tax good to have them start making gifts to me while they're alive? The answer is sometimes that is true. Sometimes it is a disaster. And if the person who actually has the money does not adequately plan, or they don't have enough money long term to meet their own needs, gifting may make absolutely no sense. The other thing I think it's really helpful to think about with the lifetime giving, and I'm going to simply do a small asterisk here because taxes are in play in this, but that could be that's a conference unto itself. So I'll simply say tax considerations come up. But the purpose of the gift may dictate the best way to handle it. So, for example, let's assume it's charitable giving. You may really want to see the benefit and the fruit of what you're giving and not just leaving what's left over at death, but you may want to see a charity you've been involved with, to receive the money you've given them, to see how it's being implemented, to be involved in the implementation of whatever that gift was. Or similarly, I have a situation with a client right now. We're going back and forth on they want to leave some money to a grandchild who has some health concerns. And the question becomes, do we leave it at our death or do we just start using it for their health concerns now? And frankly, probably lifetime giving makes a lot more sense there. So you really have to think about those kinds of considerations. Do I need the money? Does it make sense to do it now? Do I want to look at the use of the money now? Or is it something that I'm willing to let be passive and simply happen later?
Yeah, I would second. Question number one is, do you have enough to live out your days in the comfort in which you need to be? And that is Leonard's analysis. And only after Leonard gives you a resounding yes, you have plenty, do we talk about giving some of your assets away during your lifetime and what that looks like. And of course, we have lots of approaches, as Kevin said. I want to focus a little bit on charitable giving during your lifetime and the donor advised fund, just because I want to make sure everybody in the room understands what that is. And Leonard's working with Fidelity, is that right?
Yep.
We also have the Greater Houston Community Foundation, which is a public community foundation here in Houston. You can create a donor advised fund, which is like an endowment or a foundation, but you don't have to create your own foundation, do all the administrative paperwork, and file tax returns every year. You create a fund with an organization. They distribute money to charity at your direction. It can live on past you, but if you do so while you're alive, you can watch and direct it. So that's one good way to benefit charity while creating something lasting. Go ahead.
How
Leonard.
many of you have we opened donor advised funds for? If we've done that, maybe show of hands. Yeah, quite maybe half.
That's great.
And so that's, yeah, very, very, very good vehicle.
I'm a big fan.
Yeah. One thing I would say is the work we do with you on financial planning, we can slot in any gift, whether one time or every year, that you might want to do into your financial plan and see the effect of it quantitatively. So we can do that at any time. If you're thinking about something, that is the way that JC and I would go about factoring that in and determining, as Tonya indicates, what's the impact on your overall financial plan. So don't hesitate if you're thinking about something to get a hold of us and say, I just want to go model this. You may think it's just something too small and you don't want to bother us for that. We're more than happy to do it and to see what is the impact of this one thing that you're going to do. And then the second thing I would say, if it's somebody you think who may need help, whether that's a child or a friend or whatever, you might want to talk with them also. We've seen several cases where assumptions get made that they need help, and we've turned out actually they're doing all right. And so there may be some communication, some conversation. Again, and there's that word. I think in the past, people shy away from conversation, but you may decide, you know what? I want to have a gentle and polite conversation. You know, how are you doing? And more than likely, you'll get somewhere in that conversation, be able to ascertain, is your help really needed? And it may be, but you may also find out that you were making assumptions that were not the case. So, yes, yeah,
So Leonard made a couple of really good points, and there's one other aspect of what he was saying I wanted to just briefly mention. With lifetime giving, we use children as an example. This is commonly where this comes up. If you do start to give to a child, say you have 3 of them, but you give to one of them, it's not that you shouldn't do that, but you should consider that may have an effect on family harmony. That may be creating a situation where the other 2 thought that maybe this gift is a little unfair, or perhaps they should get less later on when mom or dad passes away. And the truth is, it's up to you. You can handle that however you want, but that is something to consider and to get ahead of in planning. It can absolutely be handled in estate planning, either considering those an advance gift or just letting them go as the case might be. But it's definitely something you want to get ahead of just to make sure you can avoid some family fights later on, and something to think about before making it.
How do you decide how much you will give to a beneficiary?
Well, I would start, the thing that hasn't been said yet is we don't want to disincentivize our family members from making their own way in the world and being productive people. I think that's a common goal among parents and grandparents. So finding the balance in being generous, giving during your lifetime, and watching the fruits of those gifts to people that you love, and not enabling a couch surfer who waits for the next gift, is there's a balance there. And only you know the people who are in your life. There is a federal annual taxable gift exclusion for which you do not need to file a gift tax return, and that this year is $18,000 per person. If you are married, each spouse can give $18,000 to the same person. So you can give without any consequence or reporting up to $36,000 to each person without reporting it to the IRS if you're married. That number goes up. It's adjusted for inflation every year. You can Google it and find the current number in any year. But right now it's $18,000. That doesn't mean that's the right number or a good number. It is just the number under which you don't have to file a gift tax return. If you give more than that, it is not necessarily taxable. Nobody necessarily has to pay tax on it, but you do need to file a gift tax return so that the IRS keeps track of those, what they consider larger gifts. I'm going to also circle back to don't be too generous in any one year, and always consult and have a conversation with your financial advisor about what your own needs are. I'm probating an estate right now. This is really heavy on my heart because I have a deceased former client who gave too much too early to her children. She did two things. She gave most of her worldly goods to her children and ended up living in one of their guest bedrooms at the end of her life while on hospice because she had no resources left. And she gave unequally among the children, and there was nothing left with which to equalize it. And guess who got the smallest amount? The child that she named as the executor of her estate, who is now doing the hard work of wrapping up her affairs on the planet. And so I'm thinking about her a lot today. And I know that when she made those major gifts to those children, it was for valid reasons. One needed to buy a house and needed help with the down payment. Another was educating children. All of that to be said, circling back to Kevin's equalization and family harmony perspective, we really do need to think about that if we give unequally to children. And we need to be careful about lifetime gifts that exceed our ability to do so.
That was pretty much perfect. I really liked that. I did want to tie this into the question that was asked earlier, because we were talking before about how to determine who to be your beneficiaries. In the psychology of clients in the situation, I find very fascinating. Many people do articulate, if asked, why they are leaving something to someone or giving something to someone based upon the needs of the beneficiary. I hear very often, again, 3 kids. I don't necessarily want to leave it to this one because they're doing very well. They don't need it. You could almost say they won't appreciate it because it's just a drop in the bucket. Therefore, the needs, the reason why they even picked those beneficiaries might dictate how much you leave to whom, which is totally understandable. Literally the first estate planning case I ever had when I was in law school, and I was a intern as a second-year law student, was a woman who had very little, but of course to her that was very important. She had 4 daughters. She left everything to 2, excluded the other 2. not out of any kind of bad feeling, because two were very well financially off and the other two needed every penny they could get. And so we helped her prepare an estate plan that basically left everything to the two and explained why, so there were no problems later. It was not a lack of love. It was not a lack of consideration. It wasn't to cause bitterness. They simply need it. And that's exactly what we did. And it worked out very well. So I do think, considering when you think about how much need is worth considering, I also would suggest, similar to what Tonya was suggesting, of don't give too much because they won't use all of that. I have been surprised, especially with clients who don't have a huge number of natural beneficiaries. They want to leave everything to the sole child. The child might have one child. So leave it to the first, and if not, it trickles down to the grandkid, and they have $7 million. That person, they may not have anybody else in mind, but that person, the beneficiary, is probably never going to use the $7 million. So if it's going to be too much, not just from a dissipation of that person, but if it matters to you about need, then you may want to look elsewhere for those kinds of considerations.
Or use a trust, right? This would call into question, maybe we talk about that for a second, and how, at least in that case, the trust would give the grantor some control beyond the grave. Maybe we'll talk about that a little bit and how that might bring trust into the picture.
Okay. So just sticking with that as an idea, one of the many tools we use in the estate planning world is trusts, which is a very simple concept. Is you're holding property for someone's benefit pursuant to a set of rules. So for example, I leave everything, my own estate plan. Everything goes to my wife and then to my two kids. My kids, when they're older, will not receive their inheritance outright. They'll just get a trust that sets up, one, I don't want them to waste it when they're 21, as I hypothetically would have when I was 21.
Yeah.
I have rules about what they can and cannot do with it, and eventually who they leave it to. It's a way of both making them, allowing them to benefit from what pittance I leave them, but at the same time having some level of control, so that one, it can change in the future, but two, it can protect them from some kinds of problems that I'm trying to protect them from, such as being a 21-year-old with access to money. And then frankly, for my own purposes, even further down the line, everything from the divorce. And as they are 10 and 12, I'm not overly worried about it today, but tomorrow might be a different problem, right? So the trust in that concept has enabled me to prepare for those things, leave to them in a certain way. And as Leonard was sort of alluding to, putting some level of restriction so the money will be used appropriately, stretched over need, but then ultimately allows them to leave it to whomever they want to, for beneficiaries that I haven't even considered yet. So that's one way it can be used.
And that's really this next question. We're into the area already. What primary legal mechanisms are available to provide financial assistance? So we're into it now and talking about trust. And Tonya, maybe you'll pick it up now.
I will. And we can approach trust two ways. One, we can approach trust during life, an inter vivos. You learned some Latin today. Trust. You can create a trust now that holds your assets, and the trustee, maybe you're the trustee, maybe someone else is the trustee, distributes funds according to your direction in the trust agreement. You can make a gift in your will to a trust. That's called a testamentary trust for the benefit of someone else. And again, as Kevin said, set up all the guardrails around what the money can and can't be used for. The gift does not go outright to the beneficiary. They don't have control, typically. They can't, it's usually health, education, maintenance, and support are our four favorite words. The IRS tends to leave a trust that has that distribution standard alone. That's everything you need and most of what you want. But in the case of Kevin's children, when they are at college and they're 20 and they need a car, they don't get to choose a Porsche. They're trustee. I know. I mean, unless Kevin leaves, yeah, the trustee chooses a Toyota, right? And that's what a trust can do for you. They are infinitely flexible with very little restrictions. They can be changed easily over time. This is a way that you can give and still put some guardrails around that gift. If you give money outright to someone, either during your life or in your will, it becomes their property and they can do with it what they want. And in some cases, that is appropriate, but a trust is a good way to approach it if that's not what we would want.
So I'd like to take this a little bit further in terms of the different kinds of, well, I guess is the way we say it, the different legal mechanisms. It's helpful to think of it this way, that as an estate planner, we are basically looking at a problem and we're trying to build the house to solve all of those problems, to hold your assets, to hold your legacy, to figure out how we're going to try to give it to whomever your beneficiaries are. And there are a lot of tools in our toolbox. Estate planning attorneys tend to focus on things like wills and trust because that's the thing that, typically speaking, we have to be involved in to even get off the ground, to be able to prepare, right? There are other tools. That is everything from beneficiary designations. I'd imagine quite a few of you here have retirement accounts. Those, by design, pay to a named beneficiary. That is part of the way the accounts are set up. That is not in place of, and this is what I wanted to say, a lot of clients assume that if they can name death beneficiaries, there's no reason for an estate, there's no reason for a trust, there's no reason for a will. And what happens is they do it in lieu of other estate planning. Truth is, these are all just tools in the toolbox to help us have a holistic, coordinated approach to your assets, go into the correct beneficiaries in the correct way. To take this even further, if the will, the trust, and beneficiary designations are the big three in terms of how you would pass things, the way you would leave financial assistance to your beneficiaries, you can even go further than that. There are accounts designed for minors. There are education gifting funds, 529 plans. It's a way of giving money to that beneficiary for particular purposes. You can have ABLE accounts that are very like 529s, but for disabilities. You could have, who here has ever heard of a ladybird deed? Oh, excellent. I'd imagine you probably spoke to one of us about this. That is literally a way of doing a deed that it makes it akin to a death beneficiary on your house, for example. It's a way of doing probate avoidance or other strategies to pass property to your beneficiary. So there's a whole set of options. And the best approach to this is not to do one, not to do the other, but to do them all in a coordinated fashion to get the result that you want to get.
I also want to add life insurance as a consideration. If your financial advisor thinks it's appropriate, especially if you have young families with big mortgages and a long, slow ahead of them to get kids through college, is a no-brainer to have term life insurance policies. Those of us who are past that point, including me, our financial advisors may advise us to still hold life insurance policies for other reasons, but it's a term or a whole life policy, depending on what works best with your portfolio, is an excellent way to manage a gift of cash to someone. That necessarily happens after your death.
We've gotten into some of this, but maybe this will focus us a little more. What special circumstances, needs, or ages of a beneficiary might impact your decisions?
I'll take the easy ones. Minors. Minors can't hold property. You cannot leave money to someone who is under the age of 18. They cannot legally take it. If we don't set up a trust or some specialized account, your estate representative will end up down at the courthouse to create something to hold money for a minor that will be expensive and suboptimal always, because the law is very limited. So we must create some mechanism for gifting for people who are under age 18. We don't want necessarily 18-year-olds to inherit money outright. We've learned from psychology that our brains aren't even fully developed until, and the current thinking is 25, but I have a feeling that's going to continue to change over time. And so in my practice, I start with that threshold, no matter how much money anybody is leaving a young person, I don't like to see young people inherit money outright until they're at least 25, even if it's $10,000, $20,000. Let's really talk about what we're doing and what we're incentivizing. Again, I use the word disincentivize a lot. Let's not disincentivize young people from making their own way in the world.
And I wanted to add that where I sit as an advisor, not all 25-year-olds are the same, you know? And not all 30-year-olds are the same, or even 35-year-olds. Everybody's different. And so, you know, these days, someone who's 30 may have finished graduate school just a couple of years before and has their first apartment and first job or thereabouts, right? So what does it mean if they were to inherit a couple $1 million outright? How would you react if that was you with your first job and first apartment and suddenly here's a couple $1 million, you know?
I resign.
It could be. So, you know, I think Tonya's exactly right. As we learn more about human physiology and development, I think it has a real impact on how we think about estate planning. And I think these days it's not uncommon to see phased in types of arrangements that may go for a person's entire life. It may be that nobody gets an outright grant now ever, you
Right.
know, it may be that, and we've seen quite, you know, we've seen a number of estate plans where, very, very detailed estate plans where someone, a beneficiary who is 19 gets some amount, and when they're 25, and when they're 30, and 35, and 40, and maybe when they're 45, the remainder of the trust corpus might distribute to them, you know, and others where it never does. It remains in trust for the entire life of the beneficiaries and will ultimately pass to their beneficiaries. So I think it's important that everyone come to know that you're not sitting in judgment if you don't grant outright gifts to your beneficiaries by the time they're 25, that you somehow think poorly about them or their skills or their development. I've come to think that's just not the case. It's really just part of prudent planning and recognizing the realities of modern life and what things cost and when we develop and so on. So it's my long-winded sermon about that. I don't know if you guys agree with what I said or disagree.
Absolutely. Absolutely. And I look at how much money I always look at, I do a practical back of the envelope math with clients and put a number to it. And when we put a number to it, the harsh reality of what would you do at one certain age with that much money is clarified in the meeting. If we hold money in trust until someone is 45, 50, or even their lifetime, at some point, one of my favorite things to do is to actually make the beneficiary the trustee of their own trust. They can do that. Someone else doesn't have to manage it for them when they are old enough and mature enough to manage their own trust. There's still protection in that it doesn't get included in their community property if they have an unfortunate divorce, and it's not attachable by creditors. So there are some benefits to trusts, while we can also give the beneficiary also the trustee hat as well. We've talked a lot about age, but I think we should talk about special needs trusts for people who may qualify for government support. And Kevin is actually my go-to expert for this. When I have clients who need planning for family members who are going to need government benefits, I send them to Kevin. So I'm going to give him the mic right now.
Thank you. Thank you. So this is a topic, and I'll just say generally about trust for beneficiaries. I do want to start here with saying that one of the nice things compared to the way tax planning used to be is, if we're not really going to talk about the estate tax very much today, but the estate tax thresholds used to be very low. And so most estate planning was focused on tax planning. Now the estate tax thresholds are quite high. It's basically $13.6 million per person before you meaningfully have to worry about this. And that's going to change. But focusing away from tax meant we could focus on individuals. We could focus on families. Family is messy. There's issues to consider and how and who to leave things to, as we're talking about. And so that has allowed us to do these kinds of trusts so much more that probably I would say in estate planning files, we do very conservatively, 75% of them have some kind of trust set up for a beneficiary. If it's not more like 90, I would not be shocked, but 75 is very conservative. As Tonya was just indicating, one of the many reasons why we do trusts for beneficiaries is because there either is or even potentially on a contingency could be a disability or a need for some government benefit in the beneficiary. Where does that come up? That could come up in a person who you already know is on government benefits. Were born with a disability. They've been on Social Security and Medicaid this whole time. The kind of trust you can set up for them is a trust that is totally discretionary. The trustee, the person in charge, basically can withhold the money, and they will actually use it for them, but they can withhold it. Why does that matter? So that when later on, when the government says, why should we assist you with this? You have this money here, the beneficiary can rightly say, but I can't make them spend it for me. If it's totally discretionary, if it's held back in a certain manner, they can keep the government benefit they need and still receive the benefit of the inheritance in the trust. And that is critical because sometimes people assume I'm going to leave a fair amount of money to a person who has this condition. That should be all they need. Truth is, depending on what the need is, no disrespect to anybody in this room, you could never have enough money for the amount of medical need, the amount of medical care that that person may need. Or quite frankly, some kinds of benefits, some kinds of providers are only available through government benefits. So you really do need to use that system to be able to help them with whatever their concerns are, whatever their needs are. So those kinds of trusts are used all of the time, and they're designed to be throughout lifetime. I would say too, that depending on what that kind of concern is again, as Tonya was alluding to, is we do these trusts, like before we were saying about the minors not being able to make good sound decisions with this money. To be honest, the other end is a concern too. Why would there be a need like this later on? Incapacity of the beneficiary as they age, the inability to be able to make those decisions. It's for a different reason, but the concern is there. And similarly, what is a common creditor? What is a common problem that people have as they age? Let's say hypothetically they gave away too much money during lifetime. Now they have dementia or they have a bad health ailment, and it's going to take a lot of money to care for them. They may need to use Medicaid for things like nursing home benefits or assisted living, as the case might be. Setting it up to receive in trust could solve both the incapacity problem and the benefit of holding aside the inheritance so that they can use Medicaid if they need to. We've actually done a number of estate plans leaving things to living parents. Person has no children, they leave things to their parents. That is a conversation we have to have fairly frequently. So it's a very useful tool to solve basically all of those problems.
We are just about out of time. We've got, I don't know that we're going to get through them all. Whose help, let me go through these here real quick and then we'll move to wrap. Whose help should you seek to establish and manage assistants, professionals, trustees, executors, etc.? Maybe about 30 seconds, 60 seconds, something like that.
Leonard Golub, period. And your attorney. Honestly, your financial advisor, your attorney, and if you have another person who's your tax professional.
I want to throw something in on trustees.
Mm-hmm.
I have grown very interested in the idea of institutional trustees, where we all can hire the likes of, when, in the past you think about it as the bank, but there are all sorts of now alternative trustees, alternatives to banks, financial institutions. For example, Fidelity has an extensive trust department, right? And Fidelity can serve as a trustee. Why would you want that? Well, you may not have anybody who will function well as a trustee. We have a client, for example, in another state with a $10 million or more estate. Husband has passed away, no children, and doesn't want to put her friends in the position of serving as a trustee or executor of her estate. It's not exactly that she doesn't trust them. It's not their trustworthiness. It's their ability to discharge the execution of a $10 million estate. And so Fidelity has a trust department. They charge a fee, but actually the fees have become reasonable. To what extent? Well, it used to be that it was an automatic 1%, that the bank would charge. Fidelity is 30 basis points, less than a third of what, and so there's competition that's come into the trustee area. And so you may decide that if you establish a trust and fund the trust, that you want to hire an institutional trustee, and it's become much more affordable, and they will discharge the terms of the trust, and you don't have to name your brother-in-law or your sister or whoever, who may not only not be able to do the job, not want to do the job, and you don't want to ask them to do the job. I want to throw that in on trustees because it's an area that's really been opening up to additional possibilities. And we're looking at that for quite a number of clients now.
You're right. He's right. And I also would recommend an institutional trustee if we have a beneficiary who is an addict or has a personality disorder, such that they would be a challenge for one of your friends or family members to control money for.
Imagine a sibling or a cousin, having to make judgments about, does this person in your family who's having trouble, whatever they're having to decide whether they get money.
And
maybe they can do it, and maybe they can fulfill the terms of the trust, but boy, it's
very stressful.
It's going to be stressful, and they're probably going to lose the family relationships. And so there are trustees for hire who will be the good cop, bad cop.
It's
and
great.
We'll do it for money. And so there are a lot of circumstances where everybody here may want to think about some institutional trustee for particular purposes.
It's true. And executors as well. There are professional executors as well. Your trustee manages a trust either during your life or after your death for a beneficiary. Your executor is the person who is named in your will to wrap up your affairs on the planet. They pay your final expenses, any debts, your last tax return, and they distribute money. That's the difference in those two terms. They're commonly misunderstood, but there are professional executors as well as professional trustees.
I want to talk about one other solution, is the Fidelity Charitable Group now has an endowment option where you can put money to this endowment pool, and at the time of your death, you will have designated up to 6 different charities. And rather than that money go, all the money, let's just say you have $1 million, and you don't want all the money to go immediately to the charities. There could be different reasons. It could be that the charity is a small one and isn't prepared to handle the money all at once. So what will happen is Fidelity will set up an ongoing legacy annual giving facility where the money will be given out in your name after you're dead. It acts like a foundation, right? But you don't have to have a board of directors, and you don't have to pay a tax return and manage all those things. All you had to do was pass money into this facility and name the beneficiaries. And so the Leonard and Hannah Golub endowment could be given to these 6 charities of our choice beyond our lifetime, well beyond our lifetime. And so this is a relatively new thing, but eminently available to us to give in the way that we want, and importantly, on the timeline that we want to give to. And so I encourage everybody to think about those sorts of options also. Are there conversations that you should have with a potential beneficiary regarding needs, wants, or wishes? Has that ever happened? Is it ever, do you all counsel, well, talk to them or find out? I said maybe that's a good idea before in the session today, but I don't know.
I think so. I think not assuming anything is always the best approach. I think honest conversations are always the best approach. And honest conversations with multiple children if you're going to gift to one, and your reasons why. If you're going to give unequally, I think it's good to talk about that with everybody.
How can a benefactor fulfill their own sense of meaning and purpose from their gifts?
Start with the definition of what's meaningful to you and what your intended purpose is for your worldly goods. And the internet's a wonderful thing, and Google is great. And so if you don't already know, if you're not already participating in a charity that does the good work that you would want to support, you can find one, and you can find all sorts of good information about it.
I hope just the question causes you to think deeply about the question and the answers. Just asking the question, how do I get meaning? So that we think about it more than just, oh, I'm naming a beneficiary and signing a document. It's much deeper than that, what's going on. And it can be challenging to think about it in this deeper way. This is about your meaning and purpose and your values. So hopefully the question spurs you to think about it in those deeper terms.
And I don't know how much more time we have, but quickly, I would say you need to consult with your professionals before you do something like fund a lake house or a Colorado cabin and assume that your family will want that gift over multiple generations.
So just one similar thought on that, and we don't always do this. We talk about it with some clients, is that some people have had the idea of like what's called an ethical will. I've always hated that name, but the concept of separate and apart from your estate plan, your beneficiary designations, et cetera, leave a letter. You know, our firm, we call ourselves legacy lawyers as opposed to estate planners more often than not, because you really are passing on a legacy. Things like an ethical will or a letter of intent or letter of instruction don't really say, here's my beneficiary and here's the rules. They say, here's what I hope you'll do with it. Here's why it's important to me to give that to you. A lot of times, if you're giving to a grandchild, it's because you want them to be able to use it for education. The trust might say you can use it for health, education, maintenance, and support, but you can tell that person what is important. Why was I motivated to do this? Education is important to me. Getting ahead in life is important to me. And that's a way you can share that with your loved ones.
These are so-called love letters to family or letters to
Absolutely.
family, I think
Yeah.
they've become known as. And a lot of people have decided that that sort of, while it's not a legal document, that sort of letter, that sort of document is additionally valuable to leave to your family members.
Oh, very much, because we're not going to put that language into your legal document. We don't want to risk there being any misinterpretation or any untoward legal effect of that sort of language. So your legal documents are going to be very dry and direct. And this is an excellent add-on.
One more question. What can go wrong if beneficiaries are not optimally named and endowed? I know that's a huge question, but maybe just pick a couple of them, the horror stories or something like that, that might be of interest.
Mike, or you giving me mine? Your wishes won't be followed is the answer to the question. The hard work and accumulation of wealth over your lifetime will not be to the purpose that you would intend. So it's worth taking the time and making a good plan, because what the state of Texas says should happen to your money is probably not what you want to happen to your money. One of the hardest conversations I have is when a surviving spouse with a blended family, deceased spouse had children from outside the marriage and did not leave a will. When the surviving spouse comes in to sit down with me, and I tell that surviving spouse, and maybe they've been married 30 years, that the deceased's half of her community property belongs to the children, not her. The house that she lives in is owned half by the children, because that's the state of the law in Texas. So there's a recurring horror story, unfortunately, with blended families. Blended families need to see an attorney and have a plan post haste. Any other?
Yeah, so this could be hours by itself in just terms of horror stories. As I said at the outset of this, you should be intentional. The law favors you planning. It favors you saying, here's exactly what I want. Most of the problems that come here, the horror stories, are for a lack of ability to do that or simply failing to update it. If you did a will 40 years ago, there's a good chance it's not really what you want now, and that's knowing nothing else. Individual horror stories, what could go wrong? The wrong beneficiaries, having so much difficulty gaining access to the assets that they will walk away from them. And whatever legacy you left is simply not worth it. Going to antagonistic people, going in a disproportionate way so that you basically have family Armageddon because nobody was happy in the end. Oh my goodness. I've had kids who were not necessarily disinherited, but it was so difficult to gain access to the money needed for minors to live on that I guess this was before crowdfunding, but essentially community funds were pulled together to provide for those kids until it could be fixed. That was an actual case that had a will that was done by one of those legal insurance plans. You know, it probably cost $25, and I can't even remember the number I had to charge to fix this.
Speak to that. And attorney's fees is the terrible consequence. And I don't like to make my money that way. I don't like to make my money cleaning up a spaghetti bowl. I like to earn my fair living, planning for people in an orderly way so that what they want is accomplished. And I have to charge for my time. I have to keep the lights on and pay salaries. But if someone comes to me having not made a plan and it is a tremendous amount of attorney work to resolve all of the issues, it costs a lot of money.
I am sure there are questions, but we're out of time to do that because we're going to have our last presentation of the day. The good news is both Tonya and Kevin have left their cards on the front table, and we'll be happy, no doubt, to hear from you and your questions. We're going to have our last presentation. Our team is going to talk about new stuff going on at New Capital. But it's a good sign we don't have time for questions. There's so much material here. And I have only become more and more convinced that each of us needs to think about doing more in this area. Even if we have documents, even if we did them just a few years ago, they deserve regularly updating because our lives are regularly changing and our money is regularly changing. And if we do a future value calculation on your current assets in a financial plan, you know, what you have now, it could well be beyond that 20 years from now, 10 years from now. And your estate's gotten even larger. And so in many cases, the problem, it's a good problem to have, but it's that's what investments that increase in value every year, that's what that means, is that your estate is growing larger each year. And that's, of course, what I'm trying to do with you, with your assets every year, is to grow them larger. And so there's a sort of tension there between what we're trying to do as asset managers and the caps that are put there in terms of government exemptions, but also in terms of what is a healthy and proper amount for you to leave to beneficiaries is also in tension with what we're trying to do to grow your assets. So thank you to both of you. Thanks. It's great to have you back again. And if you need any assistance at all in this area, they are, of course, of service. Okay.